We're all in this game called life. And of course, life is unpredictable. It's been said that no man can write his autobiography in advance. But one thing we can do is we can be prepared, and that's what we're here to talk about today. We're talking about trying to be prepared for the events that life throws you. Today, we're going to talk about an overview of estate planning and medical planning. You know, people of our age, our parents told us, hey, make sure you know how to change a tire, make sure you wear clean underwear, and make sure you have a quarter for the phone booth. Of course, you can't find a phone booth in this day and age, but we can at least always be prepared. So, in the spirit of what our parents told us, let's talk about some of these issues today because you never know what life is going to throw at you. You're going to have medical, you're going to have financial, and certainly you're going to have some estate planning, death issues that you're going to have to deal with. So we're about to embark on a 4-part journey to talk about these issues so you have some better insights as to take the appropriate steps under these circumstances. And because you're here today, I certainly know a thing or two about you. I know that you care deeply for your family and that you want to protect them in their difficult time in the event of your death. Or I know that you've already watched all 8 years of Game of Thrones episodes and are totally bored. So whatever the reason, we're going to talk about it today. I'm Thom Cox. I'm an estate planning real estate attorney. Been at this for 35 plus years. So we're going to run through some issues so you have a better idea as to how to plan your future. An estate plan is all about making informed decisions. It's an involving process where you have to look at the various aspects. You have to take a look at the people. Who are the individuals that you're looking to protect? What is their status? What is their age? How do we need to protect them? You need to take a look at the assets, and that's the extent of your assets, how they're held, where they're held, how they're going to be transferred. For instance, if you have property in joint names with right of survivorship, it's going to pass automatically to the joint owner of that property, even if your will says it's supposed to go to someone else. So in order for us to properly plan and strategize for you, we have to be fully informed as to assets and these individuals that you wish to leave your assets to. And of course, if the value of your estate is in excess of $5 million, we have to be concerned with inheritance taxes. Here in the state of Florida, we don't have any inheritance taxes. But if you reach that 5 million threshold, we do have federal. So we have to be cognizant of those issues. And of course, as you grow, as life changes, and that's the one constant in life is change, we need to evaluate periodically the plans you have in place because kids grow, things change, employment changes, medical changes. So it is a process that needs to be periodically reviewed and evaluated. So how do we start your estate in medical planning? So you need to ask yourself, what are my assets and what is their approximate value? So take pen to paper, write this down, get a good understanding of the things that we have to deal with. Whom do I want to receive these assets and when? And that's of particular importance because you certainly don't want to give a 12-year-old a car. You don't want to put someone who is mentally or physically incapacitated in charge of your assets. So you have to plan and strategize what you want, what is appropriate for their needs, in addition to what you believe is appropriate. So the next one is, who should manage those assets if I cannot manage them, either during my lifetime or following my death? And that's where you're going to evaluate who you want to be your personal representative. Who do you think is capable? Who is honest? Who's trustworthy? Who do you feel has the mental capacity, not only the acuity in those certain areas like investments or finance? And that's certainly maybe someone different than someone who you want to handle your medical affairs. For instance, you may have a son or daughter who's in the nursing profession, and that may be the person you wish to be your healthcare surrogate, which is different from the capacity or role of someone to be your personal representative or trustee in charge of your assets. So we've got to talk about Who wants to manage the assets? Who wants to manage your health and medical decisions? Who should be responsible for taking care of my minor or special needs children? Those are things that you need to consider also, because in the event of your death or incapacity, you certainly want to make sure you have someone in control that can carry forth your wishes. Now, your wishes may be different from what other members of the family would have to assert. You know, you may want them to be enrolled in certain schools. You may want them to pursue certain educational endeavors. And these are all things that you yourself can ensure that gets completed even after your death in creation of a trust. Those are a lot of the same issues that we encounter day in, day out. You're able to control the distribution of your assets to complete the wishes and goals that you have for your children, your spouse, whether they be minors or special needs. Who is to make decisions on my behalf concerning the care and welfare if I become incapacitated? And again, that goes back to the question of who do you want to be your durable power of attorney? Who's going to be your agent under those circumstances? And who can take care of decisions for my physical capacity in the event I have some medical or other disorders? And those are all decisions that are going to be based upon your experience, your knowledge and understanding of your family or friends or professionals that you want to fill the role as a healthcare surrogate. Now, let's talk about something that very, very confusing, and that is probate. People say, hey, I've got a will, so I don't have to do a probate. Well, let's talk about what a probate is. Probate is really nothing more than a governmentally controlled process of transferring your assets through the court system to your heirs or beneficiaries. So probate is the actual process itself. Is that what you really want to do? No. I don't know about you, but I don't want a government involved in anything that I do. The least governmental involvement, the better, as far as I'm concerned. If you have to go through probate, you've really kind of dropped the ball in your estate planning. Probate, you've got to think of it as the toll keeper. In order to get the assets to your beneficiaries, to your loved ones, you have to pay this toll keeper. You've got to go through this process in order just to have your family have these assets if you don't properly plan. Now, if you have to do a probate, it's going to cost approximately 10% of the value of your estate. So if your estate is worth $500,000, guess what? $50,000 or so is going to be spent between your personal representative fees, the attorney's fees, the court cost, claims, and other administrations. Also, with a probate, it typically takes a year or more to go through the actual process of getting that court order transferring the heirs to your assets. And what's worst is it subjects all of your assets to creditors' claims. They get a bite at the apple before your family receives the assets. And actually in Florida, there's 8 claims or classifications of creditors. And each one of these creditors have a certain priority status, such as the attorney's fees, of course, because we do the heavy lifting. Attorney's fees get paid first, personal representative fees. Of course, there's family allowance, which is a certain dollar sum for life living expenses. There are tax claims, there are secured claims, then there's unsecured claims such as Visa, MasterCard, medical bills. All of those claimants and creditors get a bite at the apple. They get to take the money before any of it goes to your heirs. So really, your beneficiaries get what's left over after you fight with all these creditors. That's why it takes a year or more before your family gets any of the assets that you have left, if you have to go through this probate process. Now, another thing about having a probate is it's non-confidential. Everything is filed within the court system, and anyone can go down to the courthouse, typically take a look at the file, and they can take a look at your beneficiaries, they can take a look at your will, they determine what assets are in your inventory, the value and type of assets that you have. They can take a look at your claimants, they can take a look at how you intend to disperse your monies. So really, doing a probate estate has left you open to vulnerable information which is being disclosed, whereby if you use a different technique to pass your assets to your heirs without going through this probate process, the information becomes confidential. Really, that's what you want in this day and age when everything can be disclosed and dispersed. And there are people who, as you know, people look in the paper every day to see when someone has passed so they can try to take an economic advantage of it, whether it's buy a house for cheap, whether it's rob a house, whether it is prey on an unsuspecting and widowed individual who may already be vulnerable in the first place. You want confidentiality. And another problem with probate is you have to do a probate in every single state where you own real estate. It's not uncommon where the family is from Ohio, owned a family farm up there. You got a certain share from your grandparents. You may own a vacation home in Colorado. You may have a beach house in Maui. Unfortunately, if you're a resident of the state of Florida, you not only have to open up an estate in Florida, which is called a domiciliary estate, but you also have to open an ancillary administration in each and every state where the property is located. And what does that cost? Well, that costs about 10 to 15% of the value of the asset because it's a separate ancillary action that has to be filed in addition to the domiciliary. So as you can see, if you put yourself through the probate process, you've unfortunately wasted time, money, and privacy. So we're going to talk about how to take care of this process or how to take care of transferring of the asset without going through probate. I know it is confusing. It is confusing. People say, look, I've got a will. I've got a will. So why do I have to go through probate? A will is nothing more than instructions to the court as to what you're looking to do. It provides who your personal representative is going to be. Some folks up north call it an executor. An executor is the individual that you have asked the court to handle the administration of your affairs, someone that you trust, someone that you feel is capable of handling those tasks. And then, of course, it names your beneficiaries. And those are the individuals that you think should receive those assets. That's really all a will provides. So if you have an asset solely in your name and you wanted to go to the heirs, the only way to get that property or asset to your heirs is to go through that probate process with court supervision and control, with creditor claims, expend all the time, money, and effort. So let's talk about ways of not having to go through a probate. So there are three ways really of transferring or having assets pass non-probatably. And I've divided them here for you. A non-probatable asset, for instance, is an asset that is jointly held or a joint owner. Think about a deed to a property that is owned by husband and wife, John Jones and Betty Jones, comma, his wife. In Florida, we call that tenancy by the entirety, and that's reserved solely for married individuals. But you can also own property in a joint ownership capacity, even though you're not married. Two brothers, Thom Jones and Bill Jones, as joint tenants with right of survivorship. So if you structure the deed in that manner, upon the death of one of them, the survivor automatically, by operation of law, joint ownership automatically receives ownership of the property without going through the court. You don't have to ask permission. Creditors don't get a bite at the apple. Second way is assets with a designated beneficiary. So, and these are in essence a contract. So think of life insurance. Life insurance, you have a beneficiary clause, which is part of your contract. It says, hey, upon my death, I want my daughter to receive the proceeds, 50%, and my son 50%. So when you die, it does not have to go through the court probate system. It automatically goes to those beneficiaries by contract. All the beneficiaries have to do is they have to send in a long form death certificate, which is lists the cause of death, to the life insurance policy, to the life insurance company rather, they have to provide the policy and they have to provide proof of identification. And then company verifies the information and within just a couple weeks sends a check to the beneficiaries without having to pay that toll keeper. You can do TODs, which is transfer on death, or PODs, payable on death, on your bank account, designating to the named beneficiaries. So even though your account is in your name during your lifetime and no one else has access to it, upon death, same type of process and procedure. Family or whoever the beneficiary provides the documentation to the bank, and the bank would give them the asset. So anything that is passes contractually with a TOD or ITF in trust for, or with a beneficiary clause with a contract goes without probate. And finally, we find the most convenient manner is passing things through a trust. A trust gives you so much more flexibility and control because a trust does more than just pass assets. What a trust does is a trust provides that the grantor, owner of the trust, during their lifetime, they're the trustee. They can do whatever they want. They can amend, they can transfer, they can collapse, they can grow, they can do whatever they want to the trust. But upon their death, immediately a successor trustee steps in to their shoes and carries out their wishes as they set forth in the trust agreement. And the trust agreement is an interesting vehicle. You got to think of a trust much like a corporation. The corporation might own assets, be it real estate, bank accounts, properties, etc. And it controls those assets. Everything is in the trust name. But even after the corporate president dies, the vice president steps in and just continues the whole process and the plan according to what you originally structured. During your lifetime, the trust is revocable. Again, you can alter, you can change, but upon your death, it becomes irrevocable or irrevocable. So the job of a successor trustee is to carry forth and carry out the wishes that you had planned. And a trust gives you so many more flexibilities. For instance, you can put in there, hey, I want my grandchildren to go to college. And if they don't go to college, they get penalized. They don't get their college paid for, or they only get X dollars, or I want them to complete this program. You can control the distribution of your assets beyond the grave, in other words. You can provide incentives or disincentives for these beneficiaries. You can protect them. If you know you want to give things to a cousin, and this cousin's a spendthrift, you can ensure that the money is sprinkled over time to this individual so they have assets for living, but they don't have complete access to the assets. You could have a child who has medical or alcohol or other dependencies. You can provide for protection mechanisms within the trust. The trust gives you total control over the assets during your lifetime and after your death. And it doesn't have to go through this probate process. Now, let's talk about probate of assets. A probate has to occur to get assets that are solely in your name to your beneficiaries, such as a house or a car. You have a car in your name, you need to get it to the beneficiaries, you may have to do a probate. You have a bank account in your name. Let's say you have a bank account, Bank of America, $50,000. Be nice for the family to have access to that bank following your death, but they're not going to. In order for the family to get that money, it has to go through that probate process where everyone gets a bite at the apple. Any other asset in your name, it flows down through the will, which the court then takes as instructions for distribution of assets, and then goes to you as the beneficiaries. Now, I keep saying the term will. What if you don't have a will? If you don't have a will, guess what? State makes a will for you. It's called the intestacy statute, and it's based upon relationship to the decedent. So the law provides that in the event a person passes without a will, they assume what you want is those folks that you're related to by lineal descent, family, is going to be entitled to the assets. For instance, if you're married, it would go to the spouse. If you have children, part to the spouse, part to the children. If there's no spouse, no children, next it goes to parents, grandparents, brothers, sisters. There's a whole lineage there. So that may or may not be your needs. But if you don't have a will or trust or any estate plan, you die intestate. The state infers and makes a will for you, and you still have to go through this probate process for the heirs to receive the assets. So that's the difference between probatable assets and non-probatable assets. Now, is there a way to transfer these assets without having to go through probate? Yes. Again, think trust, think joint ownership or survivor, think contractual transfers with a beneficiary on life insurance policies, or transfers by operation of law, joint type of account with an ITF or a POD. Simple things like this that cost very little money. These things can structure or take care of an estate plan where you don't have to go through the probate process. And no, you don't have to have, $500,000 to do a trust. And frankly, you can do majority of these techniques without having a trust. It depends upon, again, the people, the circumstances that you're looking to structure, and it depends upon your assets, how they're held, and how you want them to transfer. So do you see how it's kind of a global process that's dynamic, that changes based upon all these factors? Now, there are instruments to specifically address these estate planning needs. We have the last will and testament, which we talked about. It's nothing more than instructions to the court as to who you want to be the PR, personal representative, and who you want to be the beneficiary of your assets. It does have to go through probate. The second estate planning instrument is a trust, which we talked about. A trust is really the highly appropriate instrument for most individuals to be able to control things during their lifetime and after their death without having to go through the probate process. And finally, there's other techniques that we can utilize. There are specialized deeds. Let's talk about one for a second. It is an incredible deed that really allows assets to be transferred just like a joint ownership type of operation, but during your lifetime, you control it. What I'm talking about is what we refer to as a ladybird deed or an enhanced life estate deed. Now, this special instrument says, hey, during my lifetime, I own this property, I can control this property, I can sell it, I can paint it purple, I can add a porch to it, I can do whatever I want. I can sell this property and I don't have to get the joinder or the permission of the remainderment. But if I die and still own this property, then this property would be transferred to my beneficiary without probate. All you do is record a death certificate and the property vests automatically in the remainderment without probate, without creditors looking at it, without any other cost or expenses other than the recording of the deed. So it's an incredible instrument. Here in Florida, if you utilize this enhanced life estate deed, no creditors or claimants of the remainderment can ever attach to the property. Let's say your son has lots of medical bills or Visa, MasterCard, unsecured claimants out there, and he's listed as the remainderman to your property. Does his judgments or liens attach to your property during your lifetime? No, it does not. Does not attach to your property at all. Does it affect your homestead status of the property? No. You keep 100% of your homestead, you keep your reduced taxes, and you keep what not only constitutional homestead, which is homestead that protects you from creditors' claims, but also you keep your ad valorem tax homestead. So again, if we understand what your plans are, if we understand that you are looking to pass these assets without a probatable cost, time, and expense, and this is the sole asset, you may not need the cost and expense of a trust. You may just need to structure the assets jointly, plus this specialized deeds, and this will transfer your house upon death. Now, let's talk, since this is a survey of estate planning and medical, let's talk about healthcare and medical. And as you probably know, the number one issue concerning senior citizens is, and the fastest rising financial burden is medical bills, medical expenses. So, and it is something that we are going to have to consider during our lifetime. Everyone's going to have a medical condition, and everyone is going to, of course, die. So we have to be concerned with all of these issues. Now, the biggest concerns are who's going to make medical decisions for me and who's going to be able to handle my financial and business affairs if I'm not able to. Well, you'll be happy to know that there are ways you can structure and handle both of these affairs. One of them is utilizing something called a durable power of attorney, and another one is a healthcare surrogate. There's another instrument we utilize called a living will. Those are all the type of instruments that we utilize to make sure these issues are checked. Now let's talk about what a durable power of attorney is. Oh, a durable power of attorney is an instrument where you are the principal and you name a person as an agent. And the agent is the individual who is going to carry forth your wishes as you direct. Now, durable power of attorney allows the person to handle all of your affairs if you wish, with the exception of medical decisions. Now, this means help you with your taxes, bank accounts, investments, medical bills, lawsuits, creditors, collections, government benefits, gifts, any type of transactional issues can be handled by your agent. And this is during your lifetime. The authority and powers of a durable power of attorney end upon death. Now, the reason it's called a durable power of attorney rather than a power of attorney is because it is durable, the authority and the powers of the agent continue even in the event of the disability of the principal. And there is the distinction. With a regular power of attorney or general power of attorney, if you become incapacitated, the agent no longer has authority. But really, when do you need your durable power of attorney most? When you can't handle your own affairs. So that's why a durable power of attorney is a phenomenal instrument that allows someone to assist you when you need it most. Whether you're traveling out of town, you need someone to take care of things for you, or whether you have a medical dilemma and you're unable to take care of things yourself. Now, the agent under the durable power of attorney has the ability to handle and negotiate bills, records, things of that nature. But if you have certain medical decisions that's beyond the role of the durable power of attorney agent, that's where the healthcare surrogate comes in. Now, the healthcare surrogate, that individual's role is just that, to make healthcare decisions for you if you can't make your own. So if you can make your own healthcare decisions, you don't need the agent. The agent's authority doesn't spring to life. It's only when you're unable to make your own healthcare decisions does the healthcare surrogate jump in. And again, remember, these two people don't have to be the same individual. In fact, the majority of the time, they're not. The majority of the time, Uncle Joe is great on financial decisions. He's a broker. He's trustworthy. Great. But, he sees blood or he'll cower down to anything when it comes to healthcare decisions. But you may have a cousin who's a nurse, like I say, and that's the appropriate party to make healthcare decisions for you. Now, the role of the healthcare surrogate, in addition to having the understanding of medical background, is really to be your advocate. They're there for you. They're there to make the decisions that you have previously made under your living will. A living will is the instrument that designates how you wish your doctors, hospitals, or other medical providers to treat you, whether to give you food, water, nutrition, hydration, in the event you have a persistent vegetative state, an end of state condition, or you have a terminal condition. So this is your expression of how you wish the doctors to treat you. If you believe that your quality of life is what's important and you don't want to be artificially kept alive, you may say, look, if I can't function and I'm brain dead, please disconnect me. Some folks, some folks might say, there is a 1/100th of a percent chance that this person is going to come back to life, or there's going to be a miracle that occurs. We all hope that, but the healthcare surrogate is there to carry out your wishes. So if your decision is X, do not keep me artificially alive, then your healthcare surrogates that advocate for you and carry out your wishes. So, it's not a small task. It may not be what they believe in, but really they're there to carry out your wishes. So these are the instruments that address healthcare and medical issues. Now, your healthcare surrogate who makes medical decisions, they can get medical records. They can get medical reports. They have to work with the agent under the durable power of attorney who can get the medical bills, who can get the documentations, who can negotiate. You see, there's two different hats, two different roles for these individuals involved in this transaction. So everyone needs to work together to get an optimal resolution to most issues. Now, let's play a game. All right. Everyone likes games, right? So here we go. Let's talk about poor Lazy Larry. Our contestants for the day are Lazy Larry. Larry, as you see, he's not really made a blueprint for his estate and medical needs. In fact, he thinks that his family can just, hey, deal with it. I'm Mr. Invincible. He doesn't have a living will, healthcare surrogate, durable power of attorney, last will and testament, trust. He hasn't done anything, but he has, as you can see, plenty of Cheetos, and he is a Dungeons and Dragons wizard. Now, this is our first contestant, Larry. Our second contestant today is Simmy Sam. Fun-looking guy, huh? Simmy Sam, he's semi-retired. He likes to fish. He likes to travel. He wants to make sure he has most bases covered for his family. Sam has all the basic blueprint plan documents, which includes he has a living will, healthcare surrogate, durable power of attorney, and a last will and testament. Sam's the type of guy who understands the family, wants to make sure things are carried out, does his best. Let's talk about our third contestant behind door number 3. That would be Trusty Thom. Thom, in addition to being the most interesting man in the world, has taken a little extra time and effort to evaluate his estate planning issues and has secured a complete blueprint with additional documents to include the revocable trust agreement, organ donation or organ declaration, memorial plans, which means he's already prearranged funeral or other expenses. And because, Trusty Thom, all around good guy, loves pets. So Trusty Thom has a pet trust agreement also. So, as we said at the start of this, life happens. Let's talk about the first life event to our 3 contestants here. Each individual is currently traveling out of the country. They've all been wanting to buy a restored 1967 Shelby GT500 Super Snake. Great car. Suddenly, one hits the markets and the seller is eager. He needs cash and cannot wait for them to return from the trip. So what do our contestants do? Wah, wah, wah. Lazy Larry's out of luck. No new car for Lazy Larry. Now, Simmy Sam and Trusty Thom, they could just pick up the phone, Skype in their DPOAs. Hey, go down there, pull some money out of the bank, and scoop up that nice car so I can drive it on the weekends. All right, let's see what happens next to our contestants. On the way back from their fishing trip, I'm assuming Larry and Thom went with Simmy Sam out there on the lake. Our contestants were involved in a car accident, resulting in severe injuries, and they become unconscious and have resulting medical bills. So, as you know, unconscious means that the individual can't make medical decisions for themselves because healthcare surrogate doesn't kick in unless you're unable to make your own decisions. But again, Lazy Larry, he's at the mercy of his doctors without any of his wishes to be considered. But Our two other contestants, they're neck to neck, one each. They both have designated healthcare surrogates. They can make the medical decisions for them. They can carry out their special wishes and they can deal with all the medical bills. So, on to round three. So, it's 0 for Lazy Larry and 2 each for our other contestants. Third event, each one of our individuals has a unique child or family member situation. Hey, let's face it, we all do, right? It's not unusual to have a special needs child or a substance abusing child. So, under those circumstances, what can we do? Well, Mr. Cheetos, Lazy Larry, although regretful and remorseful, can't do anything. Life just runs its course. Things, hey, you heard it. Things just work out, right? That'll work out. I'm dead. I'm not going to worry about it. Now, Simmy Sam, he can make some provisions in his will. He can provide certain things that he wants to be distributed to his family. But he's kind of punted the decision because he doesn't state in his will who's going to take care of the child, what governmental benefits the child may lose. If a child or someone receives governmental benefits and then they receive an inheritance, guess what happens to those governmental benefits? Whoosh, they're washed away. Odds are it's going to greatly affect the child's benefits to receive Medicare, Medicaid, or other governmental benefits if they receive a large inheritance. So, is it wise to give a child or someone with medical or special needs a large inheritance without someone being in control? No, of course not. Now, Trusty Tom, he has a myriad of options available for him. He has a trust. In his trust, he's provided for his family. He has the ability to control the distribution of assets, when, where, how. He has someone in control that can make decisions called a trustee who he trusts, and they can employ agents. They can employ medical providers, doctors, specialists. They can sprinkle the money over time to these individuals. They can ensure that those medical benefits that the child might be receiving is untouched. The governmental benefits continue, but yet they still have the benefits of flow of other assets. So, Trusty Tom, I guess, is going to be the winner today. Except, believe it or not, all of our contestants have a 100% chance of dying. They're all attending a 4th of July event when they're fatally attacked by a swarm of killer bees. Now, Lazy Larry's family, they just now must administer a probate estate. They've got to go through that entire process. Of course, Lazy Larry didn't do anything, remember? Lazy Larry didn't have a will. So what happens is Lazy Larry's family got to hire an attorney. The attorney has to look at the probate statute, going to see who the intestacy parties are, have to open an estate, and maybe a year from now, after all the creditors, the claims, the medical billings, everything gets taken out of the estate, then and only then do the beneficiaries receive something. And based upon his planning so far, don't know what that's going to be. But remember, it's probably going to be only 90% of what he started with because it's going to cost him 10% to administer the estate. Now, Simmy Sam's family, they may or may not have to file a probate estate. It depends upon the assets. And remember how he structured the asset. Even though Simmy Sam only had a will, Simmy Sam could have used some of these other techniques we talked about. He could have had a life insurance policy, named beneficiaries. He could have had joint ownership of property with a survivorship passed to his heirs. He could have had POD, ITF on his bank accounts. He could have had all these other things properly structured. Would you need to do a probate? Well, only if there's assets solely in his name. Otherwise, a will is nothing more than instructions. It will not even be used in the event everything is passed through the other techniques we talked about. Now, Trusty Tom, his family should not have to endure the time, the delays, or the expense of probate, as everything should pass quickly and efficiently to his family through his trust, and again, confidentially. So no one gets to look at his trust. That's a private document that stays with his family and his attorney. So there we go. That's our contestants for today. And I think Trusty Thom wins. Simmy Sam did well, but Lazy Larry, not so good. If you have any further questions, feel free to reach out and get a hold of me. Again, Thom Cox with Cox and Sanchez. And I look forward to talking with you again later regarding more specifics on all of these topics. Thank you very much. Have a great day.